Welcome to the Secrets of Personal Injury Law with Colin B.
Welcome to the Secrets of Personal Injury Law. Joining us today is Jason Long, Senior Attorney at Colin B. and Associates. Jason leads the firm's pre-litigation department, where he works directly with clients to build strong cases before lawsuits are ever filed. I'm Sophia Morales, and today we're taking you behind the scenes of what happens before a case ever reaches court. This is Pre-Litigation Power Moves, how your attorney builds a case before trial. Welcome back to the show, Jason.
How you doing, Sophia? Nice to be back.
Fabulous. I'm looking forward to this. So tell me, what exactly is pre-litigation and how does that differ from an actual lawsuit?
So pre-litigation is, for lack of a better word, is pre-litigation. So it's not a lawsuit, but it's presenting the client's claim and their injuries and the damage model in an attempt to resolve the claim without litigation, without having to go through the trials and tribulations of lawsuit or filing a lawsuit, I should say, which can be a lengthy process and very involved. So that's the overall goal, is to try and get the claim resolved on its merits without having to go through and involve the courts.
Okay, so this is an attempt to get it settled outside of a lawsuit.
Yes.
Okay, very good. So tell us why the pre-litigation phase is so important in personal injury law.
So it is important, I guess, for a few reasons. One is it is the ability to clients' opportunity to present and treat. The way that they present their damage model is through their injuries. They're the ones that suffered the accident. They're the ones that are going through the treatment phase. So it's their opportunity to make the most of their claim. If they're claiming that they're hurt, then it's their obligation and their responsibility to go through, treat, feel better, get back to pre-accident condition as best as possible. And it's their chance for their voice to be heard sort of on the front lines before involving a lawsuit or involving the court. So it's a chance for the insurance company to try and resolve the claim amicably before they try and ratchet it up and need to go through any sort of litigation phase.
So typically what happens during this phase? Are we gathering evidence, or how does this work?
So first things first is the client will treat. They will go to the chiropractor, the physical therapy. They'll do some diagnostic imaging. They may be referred out for some pain management. Just depends on how their progress is going, really, through the team of doctors, physicians. And they go through their journey to recovery. And based on how they're doing and any additional recommendations made by the doctor, it's their chance to treat and feel better and improve their damages, really. And then they will, once they're finished with their treatment, will gather any additional billing or medical records that they do have that they've incurred, whether or not they went to an emergency room in, just after the accident or an urgent care or something like that. So we'll gather all of that evidence, whether or not they missed some days of work, prepare the complete demand and the damage model, if you will, present it to the insurance. So it's important for them to prove their case, and that goes into the prove up at this particular juncture. So it is very important.
You've mentioned damage model a couple of times. Is this kind of looking at where they started and where they ended up after they've recovered as much as they can recover, or what is this?
So it's all of the factors, really. It's the nature of the accident, from hopefully there's a police report in the matter, what happened, how, what kind of an impact it was, how hard was the impact, did the defendant do anything egregious or reckless or, extra negligent, if you will, to the injuries. What did they suffer? Did they go to the emergency room? Did they have to receive pain injections in the emergency room? Was there an overnight stay? So then they go to perhaps some, doctors of their choice, physical therapy, chiro. How are they feeling? So it's a from beginning to end, it's a full analysis of what happened and sort of a reconstruction. Do they have any pre-existing? Was any of their injuries exacerbated by the accident? Do we have what's known as an eggshell plaintiff, somebody that had a prior history of injuries or pre-existing conditions, something to that effect? So all of these factors can go into establishing a damage model and arguing for the value and the merits of their claim. Do they have residuals? Are they going to require surgery? Every case is unique, and so we use that term damage model to argue as best as we can based on the evidence that we are given.
So it sounds like you're basically preparing like you would go to court, even though you're not at the stage of stepping into the courtroom. Is that a fair assessment?
It can be fair, yeah. So, we especially like to make sure that if we are going to go to litigation, we have a good faith basis for it. We have the damages to support the argument. We have an assessment of the client, what they went through, whether or not there's any residuals. So yes, it potentially can be a preparation move to file suit. And so one of the decisions that actually goes into filing a lawsuit is, do we even have a basis for it?
Mm-hmm.
We're just because a carrier or an insurance carrier sends an offer that may not be the greatest based on the circumstances or potentially clients' expectations, doesn't necessarily mean that a lawsuit should or will be filed. Because at the end of the day, we still have to do right by the client, and if it's not in the client's interest to actually file a lawsuit, then we'll tell them.
And I think that's what I would want. I'd want you to be straight with me.
Right. Right.
There's no sense in fostering false hope. So what does the attorney do during this pre-litigation phase, and what does the client do during this phase?
The
You
client,
mentioned we've got to get healthy again, right?
right, exactly. Sorry, I didn't mean to cut you off.
No.
So the client is treating. So that they are getting better. That is what we stress from the beginning. Is the way in which you present your claim for damages is by treating. And what we are doing is we set their expectations from the beginning. That's our goal over here. We make sure that they're all on the same page. We answer any initial questions that they have. That way there's no confusion down the line. We are monitoring their treatment process. We will check in with them periodically, answer any additional questions that they have. And then once they're finished and they're feeling better, then we'll start gathering the documentation, asking some additional follow-up questions for additional information that we may need, prepare the file, get everything we need to send off a demand to the insurance company.
Can a strong pre-litigation strategy actually help to settle a case faster?
It can. I think that it's important to not hide the ball. We want to make sure that, well, I think you kind of mentioned it right there. I think a strong strategy can get it settled faster. I think that getting all of your ducks in a row, making sure that the client feels better, making sure that you gather all of the necessary bills and records timely, whether or not let's say they went to one of their own PCPs and they use their own individual health insurance, depending on whether or not that is a government insurance entity, there may be an outstanding lien that needs to be gathered as part of the claim. So there's a lot of the different things that can go into this. Record gathering, how did they feel? Did they recover well? So making sure you have sort of a complete picture. That way, when you do present the claim, the insurance company is on notice and saying, here's the damage model, here's the facts from A to Z, everything that you need evaluated. And then based on your evaluation and commentary and any additional negotiation that we might need to do, we're going to find out quickly what their position is and whether or not we have a fair offer and the client should take it, or whether or not it is not a fair offer and we should move it on to litigation phase.
So what mistakes do you see people make before they hire a lawyer that kind of hurt you in this pre-litigation phase?
We will run into clients that accept money, that somehow they don't realize that they accepted money. They'll have sort of a direct deposit or wire transfer for an injury settlement direct to their checking account. And won't realize it. They'll accept some fast cash. They'll sign a release, accept those fast cash that's given upfront, and either acknowledge it or not understand it or just sign and take things in the door. And then they walk in and say, hey, I'd like the help of an attorney. And they are asked, did you accept any settlement funds? And some of them will say yes, and we can't help them. Or some of them will say no. And it doesn't come out until we find out from the insurance company that they've actually accepted money.
How does one accidentally accept money? I'm a little confused by how this would.
So are we. It's a little bit of failure to read, failure to understand. I can understand it to a reasonable degree, as they're wading into a situation they've never been in before. So they're unfamiliar with terminology, they're unfamiliar with how things should go. They don't know whether or not they're dealing with the repairs for their vehicle, whether it is for the injuries, and the insurance company, especially the other party's insurance company that may be at fault, is not going to help them understand. It's not going to help clarify that. They're not advocating on their behalf. The other kinds of things that clients will do that jeopardizes their claim is they're not consistent in their treatment. They're claiming injuries, yet 2-3 weeks after the accident, they haven't done anything. They didn't get checked out by a doctor. They didn't go to an urgent care, and they go on vacation. And they say, okay, well, if you're in pain and you're injured, why'd you go on vacation? What
Yeah,
are you
how do
gonna,
you manage that?
what are you potentially going to tell a jury down the line, saying, well, I should be compensated for something when I didn't do anything about my injuries? And so that really puts, sort of chops off one of their legs coming in the door. Length of time makes their claim much more difficult.
Yeah, I could see that. So, are there cases where you maybe skip pre-litigation, go straight into a lawsuit?
You've got outright denials from the insurance company. You'll run into situations where a police report's just not made, and you've got a word versus word. That situation can be tricky, but if you might have a favorable witness or two that says, "Oh no, I saw it this way," and the insurance company, doesn't care, ignores that, just denies it outright. Sure, yeah, you may have a basis for skipping right in and going to a lawsuit. Um, you may have a situation where they do split decisions, or they'll put, 50-50, and they'll say, well, your client was, or our client was contributory negligent on the claim, and, there's just no proof of it. So there's no rhyme or reason, or there's just no automatic, well, this is a lawsuit. This situation means a lawsuit automatically. So every case is unique.
So, what advice would you give somebody who's just had an accident and hasn't hired a lawyer yet? They're in that stage where, they're dealing with their injuries and there are people calling, wanting statements and all of that.
You may need to speak with your own insurance, depending on your own insurance policy and the language there. Regardless of fault, you may need to call your own carrier and at least alert them to that. That's something that may be in your policy language that you need to check out. If you're injured, go get treatment, go get checked out. Don't wait. I understand that, you may be, work schedule or family or other obligations, but if you're in pain, you need to do something about it. That's essentially what it comes down to. The property damage, it will either be resolved by the other at-fault party, or you can get it done through your own collision coverage. If you have that on your policy, check your policies, go get your coverages. Most insurance carriers now have an app where you can check your coverages. You can find out, what exactly you do have. If you've got collision coverage, use it. You're paying for it. You bought and paid for it, especially when you need a vehicle to get to and from work, or to and from, your children, or your family, or something to that effect. Don't sit around and wait. Start to do and look at some of these things to try and help you faster. One of the other situations that does come up quite frequently is my vehicle was towed and it ended up in a tow yard, right? The collision was so severe that a tow truck took your vehicle to a tow yard. Well, look at your coverages. If you have collision coverage, call them and have them start to move that vehicle out of the tow yard. The reason I say that is tow storage fees accrue daily. And then at about the 30-day mark or so, you should be getting notices in the mail that says that, hey, if your vehicle is not moved, we're going to auction it off. Go get your personal belongings.
Yeah.
Go get them. Go make arrangements. It makes life easier if you have that collision coverage that, like I said, you bought and paid for, and you continue to pay for every 6 or 12 months, depending on your payments and premiums. Use it. Don't stress about my rates, especially when you're spending month to month or every 6 months in additional coverage. You basically bought something that you're not utilizing it. So don't let that vehicle get auctioned off because you're over there sitting going, well, the other party hit me, it's their fault. I'm not putting this on my own. The reason you don't want to wait is the other carrier, if a new claim needs to be opened up, that's going to take some time for them to investigate. They need to reach their insured. You don't have the luxury of waiting. And so that's one of the biggest components is people just don't know. And then they wind up going, well, what about my vehicle? And we go, well, did you get it out of the tow yard? And they go, no. Well, I mean, help yourself.
Surprise. You don't know what you don't know.
Right. Don't just sit there and go, well, the other party hit me. I'm not doing my insurance.
Yeah,
don't do that.
Exactly. You mentioned there were some places that people went wrong when dealing with insurers. What should we know in this phase so that we don't make any of those missteps that keep us from getting our full settlement?
Well, I think that might be better suited for a conversation, or I would say when they're not dealing with an attorney, I should say. So when they're trying to navigate the process themselves, they're talking to adjusters on recorded lines. And those adjusters are trying to get recorded statements. They're trying to send, trap questions and trick you questions and get you to admit things and twisting facts and twisting what you say. They're looking for ways to deny coverage. So you want to be very careful. Even when you're talking with your own insurance carrier, that can be a challenge too. There may be some policy language in your own insurance policy that says, we still need to speak with you about the accident. And that's fine in order to comply with your policy, but you also want to be very careful in what you say. Now, the caveat to my point is it's just because you want to be careful of what you're saying, the recommendation is be truthful, but just be straight to the point. Don't lie, don't exaggerate, don't twist things, but keep your statements concise, keep them straight to the point and the facts. That should keep you out of a bunch of hot water, especially when you're trying to do it yourself.
So what I'm hearing you say is probably you're best to inform your own insurer of what's going on, contact a lawyer, and then proceed from there.
That would be the easier recommended method, yes.
Okay, excellent. Is there anything else we should know before we wrap this topic up today?
Ask questions. I think that, we now have information at our fingertips. If somebody doesn't know what to do, try to do what they can. Look it up, ask some questions, get some advice before you wade into it and start making decisions, because you can turn around and regret those decisions. You say, well, I didn't know. Well, measure twice before you cut once. So I think it would be recommended that somebody ask and don't just speak with the insurance company and ask them, because if it's another at-fault party, they're not going to try and make things easier for you. They're going to do the opposite.
Yeah, exactly. They're not looking out for your best interest, generally
Correct.
Speaking. All right. Thank you so much for coming and sharing your insights on this.
Thank you.
And thanks again for listening to The Secrets of Personal Injury Law. If you've been injured and want someone to take action fast, visit boberlawfirm.com to connect with Jason and the team. Pre-litigation might sound behind the scenes, but it could be the most important part of your case. And make sure to like, subscribe, and leave a review, and share this with someone you care about.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.